To help us answer the constitutional questions is Jill Hasday with the University of Minnesota, an expert in constitutional law and legal history. Jill, good to see you again. Now, from your knowledge, has the federal government ever stripped a state of election funding over what this seems to be like a compliance dispute?
Okay, so the federal constitution, Article 1 of the Constitution, is very clear that states run elections. The federal government can intervene and pass its own laws on top of state law. So, for instance, the Voting Rights Act, which was designed to counter systematic disenfranchisement of people of color, especially in the South, is an example. But states run elections, so there's no authority for the federal government to take over elections. This proposal, as I understand it, is that federal election funds would be withheld from Minnesota unless Minnesota turned over voting rolls. Is that accurate?
Yeah, I was just going to ask, has the federal government ever tried to take more control over elections before, and how did that turn out?
Well, I mean, if you state that as generally as it is, sometimes the federal government has tried to take more control over voting. Like, for instance, the Voting Rights Act of 1965 tried to stop states from systematically disenfranchising Black people in the South, and it had a variety of strategies. In particular, if you were a state that had a history of disenfranchisement, when you wanted to change your voting rules, you had to get approval from the Justice Department before you could put those new rules in place. So states always run elections, but there are instances of the federal government being involved, sometimes for very good reasons, like protecting people's voting rights.
And would the action of Minnesota turning over voter rolls be primarily the state's decision, or would Congress or the president be able to require that?
Well, Congress has a lot of power under the spending power. So my understanding of this proposal is that it uses the carrot and stick of federal funding. If you want federal funding, you have to do what the federal government says, if this law were to pass. Generally, the court gives Congress wide-ranging authority to use its spending power to make these kind of demands on states, but there are limits. In particular, you can't ask a state to do something that would be otherwise unconstitutional, and you also can't make a demand that is essentially an offer the state can't refuse. It has to be something where a state could reasonably say yes or no, not where they have to say yes. So I'm sure if this law were to pass, it would be subject to that sort of challenge. There's also another potential challenge, which is a core constitutional doctrine in the United States is called the equal footing doctrine, which means all states have to be treated equally. So it's really in tension with that to say that one state would be subject to a rule that doesn't apply to every other state. And I think there would be a strong case that violates the equal footing principle.
We'll see how all this plays out, of course. Jill Hasday with the University of Minnesota. Jill, thank you for your time today.
Thanks for having me.